Okay, this is LAWS12059 Conveyancing, and this is topic 10, and we're almost there, people. We're almost there. Feel like a bit like we've been running the 10,000 metres, right? We've got about 1,500 to go, right? 2,000, 1,500 to go. We've got 2 topics today, and final assessment, and we're all done and dusted, as they say. All right, so topic for this tute is the anything but unimportant topic of remedies. Obviously critically important for clients. If something goes wrong, that's what they're interested in. What am I getting? How am I getting compensated? What can I do? What does the law allow me to do? Can I get out of the contract? Can I, walk away from my obligations? Repudiation of contract completely. Can I terminate the contract? I mean, the client obviously won't express it in these terms, right? Basically, the client will sit in front of you and say, "Well, what on goodness is happening here? I'm fulfilling my side of the deal. The other party's not fulfilling their side of the deal." And whether you're acting for the buyer or the seller, both sides may be wanting to pull out for various reasons, and they basically want to know, well, what can happen, what can they do, and what can they get? It's as simple as that. Okay. Now, as their advisor and as their lawyer, you need to explain to them that the law, of course, provides you with various remedies. It's really important, I think, to remind your client that basically there are remedies under the contract, and there are also remedies that the law recognises. And they might be that not necessarily under the contract, but, for example, the general law will give a remedy in damages for breach of contract. I mean, it's obviously linked to the contract, but it's not a remedy specified in the contract, okay? I mean, the thing about this topic is to just remind ourselves that the contract of sale is a contract, okay? It's a contract, but it's a particular type of contract. So you remember back to your contract law studies, which isn't all that long ago, I dare say, but there you were looking at general contracts, and much of the contract law in the general sense has evolved over time from often more individual contracts initially, if you go back far enough in history, and then in more recent times commercial contracts, but not contracts with respect to land. So this is the bugbear, right? As soon as we bring land into the picture and we have a land contract, then the law just suddenly shifts gear a bit, and it takes a different view about the matter. The contract itself, as you know, we're dealing with standard form contracts with standard provisions, 3 versions in Queensland, as we've kept reiterating, and they make provision. The contract itself makes provision for remedies if things go wrong. Clause 9.4, 9.6, 9.7, and so on. In the general law sense, the reason why we have the strong reliance on common law's response of remedy in damages is because very typically the parties do not make provision in their contract, in their general commercial contract. They can have a specified liquidated damages clause. Yes, that's not atypical, but it's not always there. So, of course, the law had to have a response if things went wrong. Now, in this area, when we're concerned, with contracts of sale of land, in this area, basically, you'd need to explain to the client, look, that you've got clauses here under the contract which give you certain rights and certain possible remedies if the circumstances of those clauses have been met. You'd explain the law tends to differentiate between the type of breach that's taken place, and it will distinguish between an important clause that's been broken. Our language for that is an essential term, or contract law, phraseology would be a fundamental term, but we talk about essential terms. But, you need to use fairly plain language with the client, but, feeding in the aspects of the law but not overly legalising it in terms of how we're doing it. For example, Grant, I just think I'm really happy and pleased with the way you've taken issue and taken up the way that you're styling and formatting, setting out your responses to a client and using, plain, direct language. But it's clear also that it's informed from the law, and there's references to the law as appropriate, to the clauses of the contract and some case law, which is great. But very direct, very plain language. That's what the client wants. Okay, and it's very interesting, just as an observation from second quiz, and all of you got the second quiz back now, that the learning aspect of that, the second part, the learning aspect, reflections there about from several of you about, oh right, in this course we've been asked or required to actually document a response to the client, not just the resolution of a general academic exercise to be, marked by Michael or whatever. And that's a skill, and that's something I've had to think about and reflect upon, but that's been useful and it's good. And that's right, and I hope it has been useful, but the point is that it's a different skill. It's a different application of writing skills and intellectual skills. The interesting thing about it actually is, I think, that it tends to fine-tune and clarify how you communicate. There's the key word, communication. And as a lawyer, as a practicing lawyer, we are communicating with all different people at different times, or maybe even simultaneously. We have to shift gears. We have to shift gears because the way we communicate to a client, the way we communicate or speak or present argument to a judge, the way we speak to a colleague, depending on whether the colleague's a senior colleague or colleague at our same level of experience, it's not the same. Not the same. Just as in general life, you talk to different groups of people, not the same. This is a skill to be developed and to be fine-tuned as you go. And that's in both in terms of oral communications and in terms of written communications. And as a lawyer, and as a future practicing lawyer, potentially in this area of law, initially at least, if not lifelong, then you will find that that's really critical, differentiating that. And so just picking up on that, Grant, and you were the only one that posted responses to these questions today. I thought it was really nice, just want to say that, and the way that's developed. And I know you've commented on that yourself as well. Just, by the way, just if you want to say anything as we go along, that's fine, and just say so. Otherwise, I'm just happy to basically present for half an hour. Is that okay?
That suits me fine. I'll jump in if I need to.
I know you will, sir, and I look forward to that. All right. So basically, with remedies, as I was saying, you're trying to explain that there, depending on what's going on and what's gone wrong, and the seriousness of what's happened, right? Then there are different remedies available, either under the contract of sale itself, and you can explain those to the client, or under the general law. And then, of course, a bit more challenging here to explain in terms of explaining to the client. And of course, you don't want to get too detailed with this with the client, but you just need to somehow find a way to communicate to them that the general law provides different types of remedies from different sources a little bit. You don't have to go into too much detail with the client about that, even though you would document it in your notes and so on. But just for our purposes, of course, to understand that there is a difference between the sort of remedies that common law provides, damages, as we know, breach of contract, as opposed to the sort of remedies that equity will recognise and the basis upon which equity will intervene. And the second or third question today, tossed up again, as you know, it's my pet area of interest, unconscionability, and how that arises in a court exercising equitable jurisdiction. I get a little bit frustrated with sometimes text writers that talk about courts of equity. We don't really have courts of equity today. What we have is, since fusion, we have a court that exercises both common law jurisdiction and equitable jurisdiction. That's the Supreme Court. Courts lower in the hierarchy can't do that. They can only basically award against legislation or against general common law. Courts higher in the hierarchy, Supreme Court and above, can exercise equitable jurisdiction. So if you're looking for some sort of response that's equitable in terms of specific performance, injunction, something like that, then you've got to go to that level of court. So, in general terms, you can sort of explain a little bit that difference to the client. It's best to use sort of practical language. So, specific performance means specifically performing obligations under the contract and so on, rather than pulling out of it and so on and so forth. Differentiate between the fact that, why would you want that sort of remedy, or why would you want to pursue it? Well, it may be that in the particular circumstances, as we've seen in previous discussions, that monetary compensation, which is what damages is, may not be good enough. Right? We might actually want to require the other party to continue with their obligations for whatever reason. Okay. So that's sort of the lie of the land, and the topic just is really basically exploring those aspects and features. One other part of that is also which is particularly relevant in this context, of course, and that's deposit, the payment of the deposit. Something goes wrong, entitlement to reclaim the deposit, and so on. And then you've got, another aspect is, the differentiation between the right to terminate the contract, to bring the contract to an end, so you don't have to do anything further on the contract, basically pulling out of it, whatever, as opposed to getting monetary compensation for a problem that has arisen by the other side, which has basically led your client basically wanting some sort of redress, or if it's about termination, to actually bring the contract to an end and not continue with that contract of sale or contract of purchase. We call it a contract of sale, but depending on who you're acting for, purchaser or a vendor, then it's either continuing with the purchase or acting for the seller, then bringing the transaction of sale to an end. All right, so if we come back to the tutorial problems for today, so we've got problem 19. So problem 19 is basically a fact scenario where we've got issues occurring between the parties with regard to the contract of sale, special condition in regard to a carriageway, a request to extend the time for completion even though time was specified to be of the essence. Now, where time is specified to be of the essence, then meeting time requirements becomes critical and essential, and the courts take particular views about non-compliance with those requirements under the contract, if that's specified. So that's there in this fact scenario. And then there's a requirement to extend the contract to allow getting the registration of that common carriageway. And then there are problems in relation to that in terms of some technical issues with the getting that easement with regard to common carriageway registered. And in the end, it all goes pear-shaped, if we can use that way of expressing it. And Esmeralda became upset and instructed you, so you're acting for Esmeralda, to terminate the contract the following day. And Esmeralda said that she wants her deposit returned. So she wants to terminate the contract, we're clear about that, and she wants the deposit returned. And the solicitor on the other side, G's solicitor, has emailed you stating that the termination by your client is invalid. So there's a protest, if you like, against the termination. Do you want to just weigh in there, Grant, and just make a few observations, if you like, based on the response you posted?
My initial observation was just on the facts. The the opposing solicitor didn't really give any grounds as to why they're saying it's invalid.
Yep.
It was just a carte blanche statement saying it's invalid.
Yep.
And what I sort of looked at, I think, towards the end of my instruction was also taking into consideration that the time period between what they were looking to do, which was the 30th, which is another 4 days away, was so close that get bogged down in litigation and a dispute and an argument. I just concluded the argument saying that although the client, I believe, has sufficient grounds to terminate, that for the sake of 4 days, it may be prudent just to hedge their bets so they had both options. When they're that close. If it was a month away or there was a major problem, then that was just something that I thought would be prudent.
Yeah, no, look, that's really good. It's very practical, very pragmatic, and that's what your client will appreciate. Okay, your client is not interested in, your response purely based on legalities. Okay, and there are going to be many situations where even if your client has rights under law to do certain things, to exercise certain rights or powers, whatever, against the other party they're involved in, they may, for very valid reasons that are known to them, commercial or otherwise, they do not wish to proceed to exercise those rights. So, in my view, a pragmatic and well-informed lawyer and legal practitioner will have sensed this and maybe discussed this with the client and provided practical pathways. What's reasonable in all the circumstances? Good to pick up on those time issues in terms of how much really we're talking about here and what's realistic, in this situation. Good to throw back, to the client. Well, you have these rights, for example, termination under clause 9, 9.5 with regard to recovery of deposit. The contract provides that, but let's be practical about this, right? Let's see if we can, look at the situation, look at how much extra time is being sought. The other good thing about what you just mentioned is, and this sometimes very often happens with junior lawyers, they can get a bit rattled by someone a bit more senior on the other side. They can just say, look, your claims of termination there are invalid. End of story. Not accepting it. Right? Oh, right. Right. Better. Well, let's come back to basics. Let's come back to first principles. Okay? First principles would teach us, okay, you're suggesting that the purported termination is not valid. What are your grounds and what are the reasons that you're putting forward that you're challenging the purported termination by my client? Because these are the reasons and this is the basis upon which I am suggesting that, and of course now you can fully engage the law back to the other side as opposed to communication with your client. At the basis of termination under the contract. So you tell me what's the basis for your argument of invalidity. So the point there is don't allow yourself, particularly early in your career, to be rattled by other more senior practitioners. And, your client has engaged you to represent them, and one can take it on faith that they are trusting the quality and the capacity of you to advise them. And if you do that thoroughly and professionally and competently, then they will continue to be your client. And because your relationship, your client-advisor relationship is built on trust, basically. So, but that trust must be informed by your attention to detail, your thoroughness, and your pragmatic approach, but a pragmatic approach that is well informed by a good understanding of the law that's relevant to the transaction. So I think that way of dealing with that is good. being pragmatic, seeing the scenario for what it represents, seeing the cracks, deliberately there, just the challenge to the validity of the termination issue when there's no real basis being suggestible, challenging that. Picking out, do we really need to launch into, litigation at this stage, but what can we do to try and work this out if we can, and how do we proceed from there? But having said that, to advise your client on what is possible under the law, and the balance between what the contract provides on the one hand and what the general law will allow on the other. Yeah. All right. Let's soldier on in the interests of efficiency, and let's come on to the next problem. Problem 20. Explain the equitable principle of relief against forfeiture. To what extent is the principle dependent upon the innocent party proving unconscionability by the party against whom relief is sought? How does the principle operate where there is a breach of an essential time clause? Now, this is getting you to explore that idea of what equity can provide. Do you want to make any comments about that, Grant?
My initial comment was that the situation tends to arise, it's sort of more of a one-way street, I think. It's where it seems to be the buyer who is typically seeking relief against forfeiture. Although it can occur the other way, I don't think that happens very often. That's my impression from the case materials and things like that.
That's right. Yep.
So that was sort of I looked at the question in that vein from the buyer's perspective.
Yep.
And very much it comes down to the unconscionability as to whether the seller has contributed or somehow led the buyer into that, into the circumstances that has led to the breach. I just want to take one little issue with you. In your response that you posted, you said the court implies unconscionability. Yeah.
Do you want to expand a bit on that?
I'm sure I read that in the case where that if the seller isn't really going to suffer from any damage, or this is my rewording of it, but if the seller's not going to suffer any real damage, then the court to me implies that, well, it would be unconscionable for the seller to exercise their rights if they're not going to be disadvantaged.
Right, that's okay. So what the court is doing is it's deducing unconscionability in all the circumstances, examining what's happening. It's not actually trying to think of another word to imply. It's not actually imposing unconscionability on the parties, but it's deducing it from what's going on. And if you've seen, if you had a chance to, but anyway, you can see it in due course, gave you some feedback on that. What's really going on here, and you've correctly referred to Tanwa, which is in the textbook, and we've looked at that more extensively in land law, as you know. Well, actually, we looked at it back in foundations, a little bit in land law, but more so in foundations. What's really going on here is the Court of Equity is on guard and very sensitive to the circumstances that might be unconscionable or give rise to unconscionable conduct or unconscientious dealing, as I've mentioned in my feedback. That's a phrase I've used, which is what the court uses. So they're scrutinising carefully to see whether or not that is there, and they will not truck anything that smacks of unconscionability as being something that can be just ignored. Because if it's there, you see, and remember, we've got a court exercising equitable jurisdiction here. Right? So if it's there, basically, if we go back to, the case law looking at unconscionability or unconscientious behaviour, that's about exploitative behaviour. It's about taking advantage of vulnerability of like the particular circumstances of the party over whom the unconscionable dealing is overbearing, if you like, and that can happen in any set of facts, any transaction. And a court exercising equitable jurisdiction will be on guard for that. If it senses that is there in the way the parties, or way one of the parties has conducted itself, then it won't accept that and won't allow that to just pass without being responded to. Anything further on that?
Not really.
Okay, that's fine. It's just something to mull over a little bit, but I suppose it reinforces the idea of the importance of unconscionability in light of conduct impacting upon the innocent party. But it's not necessarily a fundamental ingredient to establish the basis of getting relief, necessarily, but it is something that a court exercising equitable jurisdiction is particularly sensitive to, because it strikes at the heart, of course, of that which is fundamentally inequitable, which the court exercising that jurisdiction will not accept. So that's just I've just thrown that in really just to get you to think a bit more reflectively about that.
Yeah, sure.
What's this issue? What do you just think? And that's fine. It's correct on the issue with regard to equity's intervention on time, stipulation clauses, time being of the essence. Why is a court of equity reluctant? What's the basis of that to intervene where that's there?
I can't recall the case, but there was a very clear reason for this, and it do with the court not wanting to interfere between the rights of parties to contract on terms that they want to. So if a party wants to contract and waive their obligations or their responsibilities or accept liability or whatever the case, that's their right to do so.
But the court has to be convinced that's been done, like in any contractual scenario, genuinely and freely and so on, and not overborne. This comes back to the unconscionability or unconscientious behaviour. Not been overborne by something of that character. Now, because time can be critical in a land transaction for a whole number of reasons, the court is basically saying, well, if the parties have agreed to the essential time condition or time being of the essence of part of the contract, then we will accept that. We will not interfere. Again, this is basically, what I call the old chestnut, okay, of, on the one hand, respecting the intention of the parties in contractual dealings based on the underlying theory that the parties are coming to the contract basically equal and freely consenting and whatever. We know that doesn't always happen in practice, in reality, but there's that there. And so this idea which keeps lurking within the mind of the law, respect what the parties have agreed to, as long as we're convinced that they have genuinely agreed to it and there's no issues there about their will being overborne and all that sort of stuff. So accept that, because timing can be critical in a land transaction process because there's a number of other things going on. That's the reality. Right? So that, on the one hand, with the court, particularly a court of equity, making sure that it can intervene and it will intervene where it identifies matters that basically make the dealings and the transaction inequitable. And we don't know the outcome to this on every situation, every scenario, but it is a constant ebbing and flowing. It's a bit like, the tide, an ebbing and flowing. and it's an accommodation on a case-by-case basis as to how this happens, and it's evolving over time, just as the concept of unconscionability is continuing to evolve, right? So, and we don't always exactly know where the line is to be drawn, but certainly the courts have expressed the view that they won't interfere with essential time clauses where they're convinced that everything else is fine, and that for the reasons that I've already indicated. So, all right. So that's again, getting us to look at the intervention of equity in certain relief situations, exploring that idea, or the important idea of unconscionability, and also the impact in the context of essential time clauses. All right, problem 21, which I don't entirely agree. You said, I'm not sure about this. I think you did a little bad job on it. Sorry, go on.
I had, even when I was reading the original, the textbook,
yeah,
I read some of those paragraphs several times because I found it a little bit difficult to comprehend what they were trying to say.
Yeah.
I felt generally confused, so that was sort of what I thought was my best attempt.
Well, I think that's a pretty good attempt. I mean, the basic point here about, and this is the reason I've tossed in this third question or third problem on this topic, is to get you to think about the balance to be struck between the remedies that are available under the contract and the remedies that are available under the general law, and also the claim of damages under the contract. And of course, general law gives an award of common law damages, and that, the seller has to sometimes choose. It can't have everything. If you go back, for example, in the notes I indicate, and this is, just a summarisation of what's on page 478 of your text, that what's happened is that the court has basically, the law has read down the expansiveness of the remedies that are available under the contract, the idea of getting damages, for example, under 9.7 and deficiency on resale under 9.6, and then the idea of terminating under 9.1. Well, basically, what the court has done is it's read down the expansiveness of what would otherwise you would have thought would be fully available to the seller under those clauses of the contract, because basically the law is trying to come to a position here that's reasonable in all the circumstances. The general, as you know, the common law is very much concerned with that, and also this idea of the election by the seller. I mean, the seller has to think about what they want, basically, and what is more important to them at the end of the day. They want to pull out of the contract altogether. They just want to get damages. They want to get the difference when they resell the property. What is it they actually want? And this is actually something to be explored with the client. And again, I would emphasise that it's not just about pure legalities here, but it's about being pragmatic. And the client has to think about that, but they will do that in consultation with you in terms of what your advice is as to how best to proceed. And that will, of course, as ever, come back to the particular facts at hand in terms of what's most appropriate in the circumstances. So that's really what I was trying to get you to think about there with regard to that question.
In a practical sense, a client, although they'll sort of basically outline what they're wanting in their own sort of terms as to which remedy to take, most likely they're going to leave it up to their solicitor to say, well, based on what I'm wanting, which is going to serve the best purpose? Is it going to be this one or that one? You choose for me type thing.
This is the challenge that we all face as lawyers and practitioners. Remember, I mentioned to you, I think, early in the course that clients, and this presents an ethical challenge for us, that clients very often want us to make the commercial decision. And this is, making decisions about what remedy is best. It sort of, I like to describe this, it sort of masquerades as a purely legal issue, when the truth is it's actually a commercial decision that the client has to make. And it cannot defer back to you and say, well, you make the decision for me. I don't believe that's appropriate. But you can do it in consultation, and suggest, various the options that are available and what are the consequences and what are the outcome there. And then, the client has to do that. But you're quite right that the client will throw it back to you, and they'll keep throwing it back to you. And, it'd almost look at the end of the day as though you have made the decision. But you've got to be careful that and again, this comes back to your ethical obligations as a practitioner, that you must proceed on the basis of instructions. Okay, so if you're making the decision, there's no instructions. You can dress it up however you like, but and then if it goes pear-shaped, as I say, who's going to bear the responsibility and the brunt of the blame? Because the client very happy then come back and say, well, you, et cetera, et cetera. So you have to be very careful in that regard, and also to make sure the client fully understands what it is, what are the consequences of choosing this particular avenue as opposed to that avenue. But yeah, look, it's not easy and it's not straightforward. And the other thing is, as a matter of practicality and as a matter of practice, you don't often have a lot of time on these issues. And the clients don't want you to spend heaps of time on it because it's going to cost them more money. And I think, as someone mentioned earlier in the course, I think increasingly true, even now, but certainly increasingly with e-technology, you're actually going to be physically meeting with the client less and less. And your communications are going to be through various e-technology, whether it be email or some other forms of that occur in due course, more proficient. But then, and that's not exactly the same as having the client in front of you. It might be that you have things like Zoom sessions. That could be something that emerges in legal practice a bit down the track. But certainly this is a decision that the client needs to make, but with your advice and guidance, but you're not making the decision. This is the client to decide. You can advise them on their choices. You can advise them on the consequences of their choices, but it's really a matter for them. But in terms of distinguishing between, for example, damages under the general law and deficiency on resale, then you just need to explain the outworkings of that. Yeah. All right, we're a bit over half an hour. Anything else that you'd like to toss up?
I'm happy to leave it there.
Okay. So, all right, so just to wrap it up, this topic was about, the remedies that are available under the contract, very importantly, or remedies available to general law, or what can equity provide or offer given the particular circumstances of the case, and how these different mechanisms of law are working together to achieve an outcome for the aggrieved party that provides the most appropriate remedy that meets their grievance, but in light of the total circumstances. And if we end up in litigation and we end up before a court, not necessarily always, but if we do, then the court will be examining the conduct and the behaviour of the parties, and in particular, they'll be looking to see whether or not there is any issues concerning conduct to be interpreted possibly as being unconscionable, and how that might affect the sort of relief that's available. Okay.
Just a quick question on sort of litigating, if, just using one of the problem scenario examples, if there is a conflict and there is the potential or the prospect of litigation, and in discussion with the opposing solicitor, if they're providing their reasons as to what their grounds are, rather than litigating directly, is there a time that it's worth trying to get a declaration from a court on a sort of ex parte basis, just to get a statement saying this is the law as it relates to that problem, or is that something sort of not really worth considering?
No, not really. Not really. Courts won't really entertain that sort of declaratory relief very often, and they're not in the business of giving you some definitive statement on the law just for the purposes of arming you in negotiations with the other side. It comes down to your interpretation of the law, basically, and how you read it. And the great thing about law, of course, is that you get two versions of the same law on both sides, coming at each other from both ends of the table.
Yeah.
And if you cannot find some way of getting to a common point, then you will end up going through litigation, legal process. But the truth is, Grant, and for others listening to the recording, clients don't want to go there. Clients do not want to go through that process unless they absolutely have to. One of the interesting things that I was reflecting on just in the last little while was that it is interesting, I think, that very typically we, and I mean inside the academic environment, and myself as an academic, when we're designing or crafting up problems and issues, we are often very much, for some reason, we're putting them in a context of problem, issues, problems, breakdown, and legal action, right? And then please advise on what can be done, what can't be done, whatever. Whereas the truth of the matter is, and even though, of course, we use the great, vast body of law that we have, which comes out of that disputation process, the great bulk of legal matters and transactions never reach court, never reach the door of the court, because the clients have no interest in pursuing that avenue. What they want is they want to get the best they can by some sort of process, and the great bulk of the work that happens is transactional, and involves liaison and negotiation and communication between lawyers and clients. So, particularly in this area of conveyancing, that's very much the case. Looking for practical outcomes, looking for the best that can be achieved without, going off and spending lots of money and lots of time fighting each other in the court. And the truth of the matter is if you've looked at the names of parties in the sort of cases that come up, it's only in larger commercial transactions that they're fighting in the court because there's a lot of money at stake. That's the truth. That's the reason they're fighting. And if they can't be successful, they can't do what they want to do, then there's going to be very significant financial losses or consequences. So they must pursue that avenue. And from that process, the legal principles through what the court, in rendering its decisions, emerges, helps to explain the law and the legal framework. But for most transactions, that's not where it ends up. And the party's not interested in that. So it behoves, in my view, all practitioners to be robust in their advice to clients, and not shy away from. I think there's too much, particularly with transactional solicitors, transactional practitioners, shying away from giving advice on the law to support what should be done. They seem to be much more happy dealing with the transaction and dealing with the practicalities, but when it gets to advice on the law, they tend to shunt that off to counsel or whatever. I don't believe it's necessary. I mean, we've all got the same qualifications. Just because, counsel get on their back legs and stand up in a courtroom doesn't mean to say they're necessarily more expert on the law than you are. You can read the law, render the law, and interpret the law just like anyone else can. any other legal practitioner can. And sorry?
Is it also fair to say that their arguments are going to be based on their particular client? Because that same lawyer, if they're faced with exactly the same sort of factual circumstances and they're representing the other party, obviously they're going to change their arguments to try and present the strongest case they can for that client.
Of course, and this is the other chestnut in the law, is that that's right. You're trying best you can to interpret the law to represent your client and your client's interest foremost. You have to obviously you've got to be interpreting the law appropriately. You can't be twisting and manipulating it out of all proportion. But yes, that's right. Your emphasis and your focus will change. The sort of law that you consult and how you go about explaining that, reinforcing your point, will differ depending on whether you're representing one side or the other. In this context, whether you're representing a seller or representing a buyer. So yeah, that's right. And and over the course of your career, you will act for both sides in transactions of whatever kind, land transactions and others. And you'll just have to proceed with prudence and with caution and in a robust way to try and get your client to the outcome that they're trying to achieve within what the law permits, and how you interpret that on the particular facts and the contract and so forth at hand. So. Okay. All right. It's now 2:50. Are you happy to leave it there?
Happy to leave it there. Okay,
sir. All right. So we'll draw a close there. And just also, I'll post this recording in due, hopefully soon. But just to let you know, of course, I don't know whether are you able to come tonight?
I will join tonight.
All right. So just for David and Tejan, if we've got the second class on options tonight at 7 p.m. And I also will make some observations about the final assessment then too. Okay. All right. So bye for now. See you tonight.
See you later. Bye.